tight. Hold my baby squid, keep him out of sight. Talking about my life, government stay away. If you drive, I'ma do it my own way. Squid in the ocean, swimming all alone. Ain't nobody telling me where to go. Living free, gotta stay true to myself. No need for interference from anyone else. Squid pro quo, that's the way to be. Living on my terms, setting myself free. Mama to my baby, protecting with my no government intrusion. I control my life.
Good morning, everybody. Thank you for your patience with me. We've had 2 really bad storms roll through the last 2 days in a row, and I don't know. And apparently my computer decided it wanted to upgrade itself last night, and I had to restart it this morning because it did not want to load correctly. So it's been a weird day. How is everybody doing? How long before the little screams at us all? My mom is here, so probably not, because she's occupied with Nana. However, how's the voice sound today? I cut that video yesterday of the last 20 or 15 minutes of my live yesterday where I read the Jeremy Hales docs, and I realized not only was my audio off because the little my mic sits right here and the little likes to play, and she messed it up, but my voice sounded horrible. Also, I cheated. No, my goal is because I'm teaching myself how to edit so I can be a real YouTuber and not just live stream and make it easy. Because live streaming is easy, because talking to you guys, knowing that there's somebody else on the other side of the camera is super easy because I can talk. I talked for a living. Occupational therapy, I literally went into patients' rooms and I literally talked and talked and talked. So I can talk. Yeah. But talking to a camera and recording a video to me is so awkward. Knowing that there's not anybody on the other side of the camera live is weird, and I can't quite get over it. But I'm trying to be a real YouTuber. I'm trying to teach myself how to edit, and I'm trying to get over that fear of talking to a camera with nobody on the other end. So my goal is to cut some of my live streams like I used to do into smaller portions when we talk about a certain topic. So if someone wants to hear that topic but doesn't have time to watch an 1.5 to 2.5 hour live stream, you can get just that topic. But I also need to record a disclaimer that says this is part of a larger live stream, and I will link the larger live stream in the video. That way it's easy. But I'm also going to record small snippets of cases that I'm covering. I'm going to cover the Larisha Thompson case in South Carolina. She is a mom of 2 who was unalived tragically by 6 people who should not be in the country legally. And for no reason other than she was at a stoplight and they felt like trying to rob her, but they never actually got in her vehicle and robbed her. And 3 of the people who unalived her were under the age of 18. Well, 4 people were under the age of 18. 1 was 17 and the rest were 13. But she was a 40-year-old African-American woman, and you don't hear Black Lives Matter protesting for her. So the hypocrisy of certain movements in this country, I will never cease to be amazed at the level of hypocrisy that some people in this country show, which means that they don't really care. Some people in this country show. They're only trying to get attention. And it's pretty sad, and yeah, it's a pretty sad. So I'm recording a video on that. I'm editing it as we speak. But to get to the main purpose of today, what I wanted to do a couple weeks ago, but I couldn't because I couldn't talk and I sound worse than I do now. Did any of them get charged as an adult? Well, the 2 adults and the 17-year-old are being charged as adults. The juveniles, the 13 and 15-year-olds, I'm not sure. I still have to look into it. But if that trial is streamed, I will be streaming it, because that is only like 3 hours from here. That is only, and when people are like, oh, it only happens in border states, it's like, well, I'm not a border state and it happened here. South Carolina is not a border state and it happened there. ICE was actually in my town a couple of days ago. So when you say it can't happen to me because I don't live in a border state, it can happen anywhere at any time. And it just sucks. So what I wanted to do was read some of the lawsuits against our favorite lawyer on the scene. And I am feeling better overall. I am not Jinx. I am feeling better overall. It's just the voice is taking its dear sweet time. But when you have vocal cord damage, that happens. I also haven't taken any medication since last night. I took some NyQuil, and that's really only to help me sleep, so that when I lay down, we don't get the post-nasal drip and all that stuff. So, yeah. But because she's so happy, you had a partner that was shot in the stomach by a 15-year-old in 1985 in Orlando. Since juvenile violent crime has only gotten worse. I'm hoping that he survived. But I do know, being shot in the stomach, I had a patient one time in rehab. I did not work with him during his initial GSW, but where he was shot, and he was only shot because they were looking for his son and they couldn't find his son, so they shot him instead. But he was shot in the stomach, and they had to basically rearrange his stomach was not where his stomach was supposed to be. And it was, only a quarter the size. His intestines were moved out of the way. His liver everything was, if you looked at an MRI or a CT scan of his body, things were not where they were meant to be. I worked with him about 4 months afterwards, when he was not only could barely sit up, but his arms and everything. So people just think about the internal wounds that happen with a GSW, but they don't think of when you can't move your arms for so long because you're recovering, you start doing this. And half of our sessions were just trying to open up his hand. I spent hours just trying to open up his hand and splint his hand, and progressively splint his hand where he could open his hand, because that way we could work on strengthening his hand and he could actually use it, because he was like this. It's just yeah. Well, here's the thing. I'm all for holding law enforcement accountable during officer involved shootings. However, when you play stupid games, you win stupid prizes. And I've also learned through my time of researching and just seeing people, there is a thing called unaliving, self-deletion by cop, where you put yourself in a situation where you want to unalive yourself, but you don't want to unalive yourself, and you put yourself in a situation where someone else will unalive you. It's self-deletion by cop. And yeah, So things get pretty I'm not reading that first part, but she's also a lot of accounts and will carry on conversations with herself. Yeah, I was wondering. I went to turn on hockey last night, and the little was like the Mr. Squid had gone to bed, and the little I went to turn on hockey because this time of year I watch hockey. That's why I don't stream at night, and that's why I'm not in anybody's chats at night because it's hockey. Like I have a sports complex. But I turned on hockey and the little was like, no, 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 no. So it was like, okay, no hockey, turned on Paw Patrol, and I got on my phone and actually went into Megan's chat. And I'm hearing like that, I knew she had some alt accounts, but the fact that she talks to her alt accounts, I'm wondering if there's actually a diagnosis there that is not diagnosed. I'm not trying to be rude with that. I'm not trying to be hurtful with that, but I'm just curious because there are things that just don't oh, so there's just yeah, listening to people talk about that kind of recovery, it's amazing we can fix things like that. Sometimes something goes through like pitchfork, rake, or even a rock from fired from a lawnmower. It's yeah, contractions of the arms in the midline position are hard to work with them because it's painful. Yeah, it's a slow process. And unfortunately, um, it's really shitty right now because insurance companies, you have people who aren't doctors and aren't therapists telling therapists how long that it should take for someone to recover. Um, you're having someone who sits behind a desk and codes. No offense to the people who do medical coding, I cannot do that job. It's hard and it sucks. But you have individuals who are medical coders or nurses or telling therapists how long it should take someone to recover from a stroke. And it's like, no, no, no. We study years and do continuing education on how people recover from these things. And now they're telling someone you only have 4 weeks in rehab to recover from a stroke. And it's like, that's not how shit works. That's not how the body works. So we are going to read the complaint from her. Yeah, talking to yourself is okay. Answering back is an entire thing entirely. Well, talking to yourself, like here, if I talk to myself and I answer a question out loud or say a question out loud and I answer myself, sometimes saying it out loud can be a way of the brain processing. Auditory processing is a little different than processing our internal voice. So sometimes saying a question out loud, you'll all of a sudden get the answer. That's why that phrase, like, I don't know, or I can never find anything until I ask somebody. It's because you're asking out loud. And the auditory processing, your brain interprets different. So that being said, that's why it's okay to answer your own question. But when you have two different alt accounts and you're talking to yourself, that is just odd, in my opinion. Odd. Hey, King Paco. But you know me, I am not about hearsay. I am not about this person said this person said this, or the complaint against her said this or whatever. I'm about reading the actual docs. So we're going to read, this is from 2022, October 13th of 2022, the Florida bar versus Lips. And that's just what we'll call her because it's just what we'll call her. So we'll read exactly what they accused her of doing. Oh, Janet, I love that too. When I answer myself, I know I'm getting advice from the smartest person I know. There is that. All right. Let's read this. And I have the complaint and I have a couple other documents, but I also have where she, in 2023, sued them. And there is, I will show you guys this. I screenshotted it so that I could not have to go and pay for it every time I wanted to show it on screen. But there's this. There's two Pacer screenshots that I have. Let's see this one and this one. So we will look at this one. This is the first part. This is beginning, and this is hers. Federico's versus the Florida Bar. Starting in February of 2023. This is the other part. This is all the docs. There's 59 entries. So there's a lot to go through. We are not going to go through everything because even I don't have the patience for that. But we're just going to hit the main portions, like the complaint. Because that way we can know exactly what she was being accused of. And there is no rumors as to what she's being accused of. We've seen the actual documents. All right. So now that we've got our obligatory 15 minutes of all that stuff, I do have to play my little disclaimer. Here you go.
The creator does not give medical, legal, or financial advice. You may hear opinions on this channel from the creator and guests that you may not agree with, and that is okay. Everyone is welcome to their own thoughts, views, and opinions, and this is a place for open debate and agreeing to disagree. Thank you. Do not contact anyone discussed in this stream. If you do, you will be blocked from this channel, and then continuously shamed by the creator and the chat for being stupid.
There's my disclaimer, guys. I love you, but we are going to make sure that I have not told anybody to reach out to anybody. What you do in the 22 hours a day that I am not streaming is your business, but I do not condone reaching out to any of these people. We are talking about facts. I am not implying anything. We are talking facts and facts only. Oh yes, I am convinced that there's also a thing of lawsuits are expensive. Lawsuits are very expensive, and when you have when you owe money to people already, that is proven, back taxes and stuff, that's public record. When you owe money and you're filing these lawsuits, things can add up. So I also do have the lawsuit from her husband that he was involved in a case with Judge Boletho. I have the lawsuit. It looks like he was an attorney of record. I have to look at what the lawsuit is, but I went on Pacer and I just searched for names, and it doesn't matter what district. I just searched for names and I found her. So when people have asked, it's when people have asked what I've talked, or that why does her husband let this happen? I believe because that ABC Legal lawsuit that I read last week, her husband is the attorney of record for the child involved. So I believe that he is, in my opinion, he is just as litigious as she is. So there's that. All right. This is the complaint, the Florida Bar against her. Florida Bar complainant files this complaint against her respondent pursuant to the rules regulating the Florida Bar and alleges respondent is and was at all times mentioned under herein a member of the Florida Bar admitted on April 22nd, 2017, and is subject to the jurisdiction of the Supreme Court of Florida. Respondent resided and practiced law in Orange County, Florida at all times material. The Ninth Judicial Circuit Grievance Committee C found probable cause to file this complaint pursuant to Rule 3-7.4 of the rules regulating the Florida Bar, and this complaint has been approved by the presiding member of that committee. Count 1. Florida Bar realleges paragraphs 1 through 3. Respondent represented, and I'm not going to name the names of the people that she represented because it's in here, it's a matter of record, but I just don't like mentioning people's names who really aren't involved. You know me, like this person who she represented has nothing to do with why I'm reading this lawsuit. So, Wednesday, it's Tuesday, you scared me. Well, Tuesday here. Oh yeah, it's Tuesday. It's Tuesday. It feels like a Wednesday. Like, and you know how normally this room is lit up without any of my lighting. If I were to turn off my light right now, this is what my room looks like. This is how dark it is outside at 9:40 a.m. Oh, Kat and Karen, how are you? If you haven't hit that sub button yet, please take a second to do that. Yes, I'm actively working now because I've been sick and life took over and I haven't been actively working to grow my channel, which is kind of fine, but I am now. Yeah. Respondent represented her in Walters v. Schuchard. Respondent failed to diligently represent her client in her family law matter. Respondent filed deficient certificates and notice of compliance in that referenced items were not produced, or if provided, they were not fully produced. Where does this sound familiar? Does this sound familiar to anybody? Just a thought. Does this, referenced items were not produced, or if they were produced, they were not fully produced. Oh yeah, for you it's Wednesday. That's true. In addition, respondent provided incomplete financial affidavits. Attorney Daniel Freiberg, opposing counsel, filed a motion to compel respondent's compliance with Florida Family Court Rules of Procedure 12.285, financial disclosure on October 16th, 2020. It's always about the money. In every case, every situation, everything on the internet that you see, every politics discrepancy, it's always about the money. Follow the money. Follow the money. When attempts to gain compliance without court intervention failed, the motion was granted by the trial court after a hearing was held on November 3rd of 2020 and memorialized in an order dated November 10th of 2020. On March 2nd, 2021, Mr. Freiberg filed petitioner's second motion for contempt and enforcement that was heard by the trial court on May 12th of 2021. The order entered on May 26th of 2021 in response to petitioner's second motion for contempt and enforcement stated, counsel for the respondent appeared and explained to the court that she had forwarded all requests for discovery to the respondent and produced to counsel for the petitioner everything she had received. She informed the court that she has a dedicated site where clients are to deliver discovery documents, and her client is aware of the dedicated site. Sounds like they all met at the aisle at the supermarket. They have one of those? I wasn't aware that they had one of those. But hey, is that between the soda aisle and the snack aisle where all that processed artificial sugar is?
Yeah.
At the May 12th, 2021 hearing, respondent disclosed information regarding her attorney-client relationship with Ms. Goldburn to the court and opposing counsel. Further, a conflict arose between respondent and her client as reflected in the explanation provided by a respondent as detailed in the trial court's order. The trial court found Ms. Goldburn guilty of civil contempt and ordered her to pay the petitioner's attorney fees in the amount of $1,000 due in 2 equal payments of $500. Why? Yeah. 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 Respondent also failed to provide Ms. Goldborn with adequate communication. Lucky number 13. Respondent failed to notify Ms. Goldborn of the hearing that took place on May 12th that ultimately resulted in her being held in contempt. I mean, if I were that client, I would be pissed. I don't know about y'all, but I would be pissed if I was held in contempt because my lawyer failed to tell me something. I would. Oof. Good morning, Roy. Hugs to you. Hoy, just in between the pharmacy and the Get a Life aisle. Is that where the condoms and the pregnancy tests are? Asking for a friend. On or about June 22nd, 2021, 1 week after Ms. Goldborn's first payment was due, respondent forwarded an email from Mr. Freiberg enclosing the order. This correspondence was the first time that respondent notified Ms. Goldborn of the order. Jesus, Pete, man. By reasons of the foregoing, the respondent has violated the following rules regulating the Florida Bar. 3-4.3, misconduct and minor misconduct. The standards of professional conduct required of members of the bar are not limited to the observance of rules and avoidance of prohibited acts, and the enumeration of certain categories of misconduct as constituting grounds for discipline are not all-inclusive, nor is the failure to specify any particular act of misconduct be construed as tolerance of the act of misconduct. The commission by a lawyer of any act that is lawful or contrary to honesty and justice may constitute a cause for discipline, whether the act is committed in the course of the lawyer's relations as a lawyer or otherwise, whether committed within Florida or outside the state of Florida, and whether the act is a felony or a misdemeanor. Yeah, oopsie, just doesn't cover it. Boy, there was one of Judge Fleischer's lawyers who forgot to tell their client that they had been in court for one of the hearings and they just rescheduled for the next day. I mean, and I can understand lawyers forgetting things because, like, they have a lot to deal with. Like, a lot of people have a lot to deal with. But multiple times, like, you not only fail to tell this person that there's a hearing, but then you fail to tell them that they're in contempt and they owe money. That's multiple. Drive safe. 4-1.3, diligence. A lawyer shall act with reasonable diligence and promptness in representing the client. See, this is the reasonable diligence. Like, forgetting to tell your client one thing is like, oh my God, I'm sorry. But when it happens over and over and over again, it's no longer an accident. 4-1.4, communication. Informing a client of status of representation. A lawyer shall, 1, promptly inform the client of any decision or circumstance with respect to which the client's informed consent, as defined in terminology, is required by these rules. Reasonably consult with the client about the means by which the client's objectives are to be accomplished. 3, keep the client reasonably informed about the status of the matter. 4, promptly comply with reasonable requests for information. And 5, consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows or reasonably should know that the client expects assistance not permitted by the rules of professional conduct or other law. Yeah, isn't that why lawyers have calendars? And this is why your girl keeps not only a written calendar, but an electronic calendar. Like, because if I don't write something down, I'll forget. Has anyone actually talked to her attorney? Who's attorney? B, duty to explain matters to a client. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. 4-1.6, request consent required to reveal information. A lawyer must not reveal information relating to representation of a client except in stated subdivisions B, C, and D, unless the client gives informed consent. She is her own attorney. Well, and here's the thing too. Like, look at these. So not only look at these rules that we're reading in relation to this complaint with this person, but look how this reveals, or this is what another lawyer who shall remain a bubble brain was supposed to adhere to by having a pro hoc vitae motion to practice in the state of Florida. So hey Lisa, so you can read these things out and you can look at a lawyer must not reveal information relating to the representation of a client except in stated subdivisions B, C, and D, unless the client gives informed consent. My question is, did Lynette, and this is my plain devil's advocate, did Lynette and John ever give informed consent for Bruce to talk about their case so many times and say everything that he said on all those podcasts? Did they truly give him that consent, or did he kind of force their hand? There would be an interesting, yeah. Oh, on the case against Tug, Megan J., her husband is listed as her attorney. I hadn't looked at that case in a while since they dropped Megan, and also since she filed a motion on her own to keep it confidential. Since the judge hadn't ruled on anything yet, I decided not to. I got better stuff to do. 4-1.7A2, representing adverse interests. Except provided in subdivision B, a lawyer must not represent a client if there is a substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by personal interest of the lawyer. It's another one where I'm like, yeah, I thought, and it said she was that. Well, I think when I read it, there was a question because she wrote it, and we can look at it when I'm done here. But she wrote it. The first paragraph was by and through undersigned counsel, which made me think that she had counsel. But then she signed it pro se, so there was a question there. Because you don't say by and through undersigned counsel when you write pro se. I've seen enough pro se motions to write, when they write that first paragraph, it's by and through, by whoever pro se defendant. And you can see she's written it on other things where she's represented herself pro se. You'll see what she writes when she's pro se versus by and through undersigned counsel when she signed it pro se. If I were a judge, that would get the hamster on the wheel of like something hinky here. I am not a lawyer, so I don't know exactly what would be hinky as far as the rules regarding that. and specifics. But to me, that reading enough documents in my life, something's hinky. Oh. Oh, a lawyer must not, in pretrial procedure, make frivolous discovery requests or intentionally fail to comply with a legally proper discovery request by an opposing party. So this is against lips, but you can see all the things in here that apply to another attorney who shall remain bubble brain. He hasn't been around in a while. Like, not that I want to communicate with him, but I haven't heard from him in a while. He hasn't emailed me in months, and I'm like, did he finally start ignoring me and not caring? Like, thank God. 4-8.4, a lawyer shall not engage in conduct in connection with the practice of law that is prejudicial to the administration of justice, including to knowingly or through callous indifference disparage, humiliate, or discriminate against litigants, jurors, witnesses, court personnel, or other lawyers on any basis, including, but not limited to, on account of race, ethnicity, gender, religion, national origin, disability, marital status, sexual orientation, age, socioeconomic status, employment, or physical characteristic. I don't know, like calling someone names in an email, calling a certain lawyer, just to, we'll just, I don't know. You can, not naming names, you can, if you know, know. All right, count 2. The Florida Bar realleges paragraphs 1 through 3. Attorney Michael Lundy represented the mother and respondent represented the father in a paternity action. Respondent conducted a deposition of the mother on April 13th of 2021 and questioned the mother regarding any past criminal conduct, substance abuse, and her observations and experiences with the father. In 2 pleadings filed with the court, respondent made misrepresentations. On September 8th of 2021, respondent filed father's urgent motion for supervised visitation of the mother, wherein she made a number of misrepresentations with regard to substance abuse and past criminal conduct by the mother. These misrepresentations were designed to lead the court to believe that the mother should be subjected to a psychological evaluation and supervised visitation with her child. I think he's just as bad as she is. Doing my research and seeing what his name has been involved with, I have not gone through anything on stream of what he's been involved with, but I think they're 2 peas in a pod, so to speak. No pun intended. But it's my personal opinion, and you can agree to disagree with me on this one. But I've been involved in enough. Well, I've seen enough family court firsthand, from having to write letters for friends, because their ex-wife decided to try to pull an Amber Heard with an order of protection. That I believe that anybody in a divorce setting where a child is involved, I just think a psychological screening should be I think a psychological screening should be just a part of family court. Not a full eval, but just a screening, because there are some things that family court does and leaves people with parents that have some severe mental health issues. And that is not to disparage anybody with a mental health issue. That is just to make sure that people who cannot take care of themselves, like innocent children, are not put in situations that they cannot get out of, because children are innocent and can. There's a reason that children are with guardians and parents, because they cannot take care of themselves. They are not mentally and physically developed enough to care for themselves. So it's my personal opinion that with family courts, just anybody involved in the family court system should just be screened for mental health issues, for their safety and the safety of all children involved. It's not a it's not a it's not to disparage anybody with a mental health issue. And I believe just because you have a mental health issue doesn't mean you shouldn't have your children in your custody. It just means that I believe that you should be getting the help that you need, because we have a lot of undiagnosed mental health issues in this country. And it can get to a point where you see stories about tragedies, about parents doing things to their children because their mental health got out of control. So, and when one parent accuses another parent of misconduct, I believe that parents should be screened for, not all parents, but if you're going to use the family court system, the family court needs to know, so that they can make accurate decisions with the most amount of individuals present. So because of the things that happen and the untreated, and that's not to stigmatize mental health issues, because there's people who have mental health issues who truly need help, who aren't getting it, but there's also people who don't have mental health issues that hide behind mental health issues because they want attention. So it's one of those touchy subjects where it's difficult to talk about because it's nuanced. Not everything is, but that's one of the reasons I love talking about things like that on this channel, is because we realize that the world is nuanced and we don't live in a one size fits all world. And everything is nuanced. Yeah, I also believe that there should be drug screenings for family court. If you're gonna fight for paternity of or for custody of your children, and try to take custody away from a father who might just be the best person in that kid's life, and just you're trying to take custody away just because you don't like them, I believe, just like I believe that there should be drug screenings for welfare, because drugs are a huge problem. And if you're on drugs and you get money from the government, are you truly using that money for what it's supposed to be intended for, or are you using it for drugs? And if you are on drugs, then you can get help. So it's not a one size fits all, and that's why I'm saying screening and not like treatment. There's a difference. It's like when you go to a doctor after you have a baby and your OB gives you a questionnaire to screen you for postpartum. She's not diagnosing you. She's not telling you have it. She's just asking questions to get an idea of what she might be dealing with, or you might be dealing with, so she can get you the appropriate, You've seen horror stories about this. Yeah, I had to write a letter to a judge in my home state for a friend of mine whose ex-wife not only got an order of protection, but tried to take away this person's ability to see his children because of she didn't like him. And she said that he was abusive, and I had never seen this man be abusive, and knowing him for over a decade. So I wrote a letter to the judge. First time I've ever written a letter to a judge like that. And hopefully the last time I'm ever going to have to. Hey, She Nemesis, how are you? Yeah, that's the problem. Problem is, in the US, you have insurance companies saying how long an assessment period needs to be, not the assessor. In UK, it's free, but not enough practitioners due to need. Oh, and I did find out some information too about why prescription drugs are more expensive here than they are in other countries. We're actually paying for the subsidies of other countries. Yeah, I'll have to do more research on that before I tell you guys the ins and outs, but it was really interesting that the reason like the UK and Canada gets cheaper drugs is because the US pays for a bunch of the all of the research and testing and all of that so that the companies can sell drugs to other countries cheaper. Yeah. So we're getting screwed over yet again. Like, we're producing the drugs to treat different ailments, yet they're the most expensive here. Make it make sense. Yeah. My mom has known this person for a long time too, and never seen them be abusive to anybody. And if my mom has any reason to make allegations against this person, it would be her. Get over here. All right. The allegations made in the motion were not supported by the mother's testimony as transcribed in her April deposition taken by the respondent. At a September 9th of 2021 hearing, the court addressed the motion and stated, I'm reading this motion. This does not seem like a petty or pretty strong mischaracterization of what happened at that deposition. And Miss Lips, I find this motion to be unbelievable. The court further stated, sounds like to me you took a deposition, the pertinent questions weren't asked. You decided to make claims that you have not verified because you wanted to retaliate because they've made the same claims about your client. Sound familiar? Yeah, there's always exceptions, and it's nuanced. That's a nuanced exception. Come on, let's go out here. No. At the end of the September 9th, 2021 hearing, respondent orally moved to withdraw the father's urgent motion for supervised visitation of the mother, and on the next day, respondent filed a notice of withdrawal of the motion. Fancy that. On September 8th, 2021, respondent also filed father's motion for attorney's fees, costs, and suit monies wherein the respondent made similar claims regarding the mother that were inconsistent with the mother's deposition testimony and unsupported by any evidence. It's one of those things of anybody can say anything at any time, but if there's no evidence to support it, is it like... Yeah, so all the people saying we need to update our medical system to match other countries. What country is going to pay for the U.S. to get cheaper healthcare? But, yeah. It's a matter of U.S. drug companies want to be the sole suppliers. So EU has set a max amount to be paid for drugs. If U.S. drugs are too expensive, they would lose out on non-U.S. pharmaceuticals, which makes those drugs more expensive here. And there's more nuance to it as well. I have to research what I saw to know further details, but there's the basic gist of it. Kind of sucks, doesn't it? Respondent also made misrepresentations in a third pleading that was sent to the court ex parte and not filed with the clerk of court. As you say, follow the money. It's all about the money. All about the money. Respondent submitted former ex-husband's ex parte motion to compel discovery, dated September 9th, 2021, to the trial court. The motion included a certificate of service alleging that the document had been furnished electronically to the clerk through the e-portal system and to Mr. Lundy. However, Mr. Lundy did not receive this document from the respondent on September 9th of 2021. Further, the document was never filed with the clerk of court. Yeah, her and Nana are running around the house. She's a happy little girl. Like, she has her moments, but for overall, like, she is a very happy little girl. The motion asserted that Mr. Lundy and his client failed to respond, file an objection, or seek an extension to the discovery demands served on the mother December 27th of 2020. Respondent's motion inaccurately stated the respondent conferred or attempted to confer with the opposing party prior to seeking court action. Doesn't that also sound familiar? I tried to confer with you, but you never picked up the phone. Or you hung up with me. Ugh. Ugh. Hi, Tammy. Have a good day. Yeah. It's like 50 Shades of Bruce. Like I said, birds of a feather flock together. Contrary to the respondent's assertions in her motion on January 26th of 2021, opposing counsel had in fact responded with a pleading titled Mother's Objections and Motion for a Protective Order on Father's first request to produce dated December 27th, 2020, and first set of interrogatories dated December 27th, 2020. That was filed with the clerk of court and served upon respondent. In her sworn statement to the bar, respondent testified that if you file a discovery request and the party fails to respond, one is permitted to obtain an ex parte order from the court. Respondent did not believe that she was required to file the ex parte motion with the court. Respondent further testified that she believed she spoke to Mr. Lundy's co-counsel regarding the discovery issue before filing the ex parte motion and later abandoned her attempts to compel discovery when she learned that opposing counsel had responded. That I don't know. I want to say it was paint chips, but that would not 100% be accurate. I have no idea. And I also agree. The medical marijuana stuff. I think that should be a federal thing. And the reason I say this, and normally I'm so against federal regulations on anything and leaving it up to the states, but that is so nuanced. Violate, brethren. That is so nuanced, especially on people who live like, I'll just bring like Texarkana, because everybody knows Texarkana. There's a Texarkana, Texas, and Texarkana, Arkansas. Because people can live in one state and work in another, you might have that medical marijuana card and be using it in the state you live in, but you can go to work, get drug tested at work, fail, and be in trouble legally with that state because you did something legally in your state. It's so that I'm all for states' rights, but that is one of those like catch-22s where I think it should be like a federal blanket, either legal or not legal, because of the fact that there's a lot of people, like I know a lot of people who live in Wisconsin because taxes are cheaper, but work in Illinois. It's legal in Illinois. It's illegal in Wisconsin. So it was like, or at least when I moved, I don't know what the laws are now, but it's one of those like, you're legal in one state, but you go home and all of a sudden it's illegal. So you could get arrested at your house, but you could smoke at work and it'd be fine. It's so, yeah, it needs to be, yeah, federal. That one is the only one where I'm like, the feds need to figure out the rules so that everybody's the same, so that a person doesn't follow the rules in one state and get arrested when they go to work in another state. It's so, and I know that doesn't affect many people, especially people who live like in the middle of their state. Like they never go to another state, but like we are so close to South Carolina here that I know a lot of people who go to South Carolina like so easily. And if laws are different, you're screwed. Like where we go hunting is on the South Carolina border. I'm in the river and I'm fine and I'm legal for Georgia. But the minute that I land my kayak on the other side of the river, I'm technically illegal because I don't have a South Carolina hunting license. So if my kayak flipped and I had to swim to shore and I swam to South Carolina to keep from drowning, I would technically be illegal and subject to arrest. Make it make sense. Technically, it's illegal in all states since it's still on the federal schedule. That is true. Yeah. Yeah, and I just used it as like a generality to kind of like, I know that a lot of times you can't smoke at work, and a lot of jobs like healthcare you can't smoke at all. Like, but it's one of those, you know. Yeah, exactly. I would not want my pilot to smoke before he tried to fly. Like I get it. Like there's, once again, it's one of those topics that's nuanced. But because of interstate travel, how easy interstate travel is, that needs to be a federal thing for my, yeah, and that's true. But so does alcohol. So so does alcohol, and so does alcohol, and so does a lot of prescription drugs. So that people get legally. So, you know. And if you've listened to certain people's streams the other day with how much coffee and Dr. Pepper they've drank at the same time, even that can impair your judgment. Not naming names. But if you know, you know. I'm going to get an angry message about that. How dare you talk about my coffee and Dr. Pepper use? By reason of the foregoing, respondent has violated the following rules regulating the Florida bar. 3-4.3, misconduct and minor misconduct. Standards of professional conduct requires members of the bar are not limited to the observance of the rules and avoidance of prohibited acts, and the enumeration of certain categories of misconduct as constituting the grounds for discipline are not all inclusive, nor is the failure to specify any particular act of misconduct be construed as tolerance of the act of misconduct. I love how legal things are written where it's like a run-on sentence from hell. The commission by a lawyer of any act that is unlawful or contrary to honesty and justice may constitute a cause for discipline, whether the act is committed in the course of the lawyer's relations as a lawyer or otherwise, when committed within Florida or outside the state of Florida, and whether the act is a felony or misdemeanor. Diligence, again, a lawyer shall act with reasonable diligence and promptness in representing the client. 4-3.1, a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous. Which includes a good faith argument for an extension, modification, or reversal of existing law. A lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. 4-3.3, A1, candor toward the tribunal, false statement of material fact. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made by to the tribunal by the lawyer. David Gingras, this is the reason why he'll never practice in Florida. Just one of those things. Hey Shane, how are you? How is the future? And Kasha, good morning. 4-3.5b, communication with the judge or official. In all adversary proceeding, a lawyer shall not communicate or cause another to communicate as to the merits of the cause with a judge or an official before whom the proceeding is pending, except in the course of official proceeding in the cause, in writing if the lawyer promptly delivers a copy of the writing to the opposing counsel or to the adverse party if not represented by a lawyer, orally upon notice to opposing counsel or to the adverse party if not represented by a lawyer, or 4 as to otherwise authorized by law. 4-8.4. Hey, Aussie Just Jen, how are you? It's personal preference. I just like it when, like this, Mama Squid. If you go to a restaurant, they have tea and unsweet tea. They don't label it as sweet tea most oftentimes. Sometimes they do, but most oftentimes it's just tea and then unsweet tea. Whereas normally most of the rest of the world thinks of tea as just tea without sweetener or anything, and then sweet tea has the sugar added. It's a play on words. Ugh. I'm getting over bronchitis. I feel fine most oftentimes, but my voice just has not. My voice is still on the yeah. I'm coughing, but I'm not coughing very much. My voice just is a day late and a dollar short when it comes to recovery. It's gonna take some time. My it's still gonna be like a week before my voice gets back to normal. I only put a little bit of sugar in a gallon of tea. Yeah, a bag. I only put a little bit, just like 5 pounds. When I first moved down here, Mr. Squid would go through a gallon of tea in like 3 days. I haven't made sweet tea in this house in like a year. I'm wondering if there's something wrong with him. I'm coming. Or as otherwise authorized by law. 4-8.4, a lawyer shall not engage in conduct in connection with the practice of law that is prejudicial to the administration of justice, including to knowingly or through callous indifference disparage, humiliate, discriminate against litigants, jurors, witnesses, court personnel, or lawyers on any basis, including but not limited to, we've read this a sentence ago, or a couple pages ago. Sweet tea is a staple in the South. One thing I hate about Pennsylvania, and they were like, we have sweet tea. I tried it and I was like, yeah, this is not sweet tea. Yeah, I'm not a sweet tea fan, but I'm just not a tea fan in general. Like, occasionally I'll drink tea, but it's not, like, I have this white chocolate peppermint tea. That's really good that I'm obsessed with right now. But, like, I'll drink it, I'll finish this container, and then, like, I won't drink it for, like, a year or 2. And then I'll be obsessed with, like, lemon hibiscus tea, and I'll, drink it for months, and then I won't drink it ever again in my life. I'm a... Oath of admission to the Florida Bar. I do solemnly swear I will support the Constitution of the United States. Some people should read this over again. And the Constitution of the State of Florida. I will maintain the respect due to the courts of justice and judicial officers. I will not counsel or maintain any suit or proceedings which shall appear to me to be unjust, nor any defense except such as I believe to be honestly debatable under the law of the land. I will employ for the purpose of maintaining the causes confided in me to such means only as are consistent with truth and honor, and will never seek to mislead the judge or jury by any artifice or false statement of fact or law. I will maintain the confidence and preserve and violate the secrets of my clients and will accept no compensation in connection with their business except from them or with their knowledge and approval. Alec Murdaugh. To opposing parties and their counsel, I pledge fairness, integrity, and civility, not only in court, but also in all written and oral communications. I will abstain from all offensive personality and advance no fact prejudicial to the honor or reputation of a party or witness. Unless required by the justice of the cause which I am charged, I will never reject from any consideration personal to myself the cause of the defenseless or oppressed, or delay anyone's cause for lucre or malice. So help me God. Jeffrey. Some need to read it for the first time. I feel like I need to clip that and make that a short. Count 3. The Florida Bar re-alleges paragraphs 1 through 3. In that case number, a dissolution of marriage matter, respondent filed a notice of limited appearance with the stated purpose of requesting a motion to continue for a hearing set on March 15th, 2022, on behalf of the husband. There was no hearing scheduled for March 15th, 2022. However, there was a hearing set for March 16th of 2022 on the wife's motion for exclusive use and possession of the marital home, temporary access and contact schedule, temporary child support, order compelling mandatory disclosure and awarding attorney's fees, costs, and other relief, filed on January 24th of 2022. Bye, Paul. Have a good day. Guess some lawyers we know have never read that. Yeah. Respondent appeared on the husband's behalf at the March 16th hearing. The parties were unable to conclude the hearing. While present for the March 16th hearing, the parties, including respondent, coordinated and set a continuation of the hearing and case management conference on April 18th of 2022. On April 11th, respondent filed an emergency motion to continue seeking a postponement of the April 18th hearing. An order granting a continuance, resetting the hearing to May 9th, was entered on April 14th and served upon respondent. On May 9th, respondent failed to appear for the hearing and the magistrate was unable to contact her by phone. The hearing was reset for May 20th, and respondent was served with a notice of hearing by opposing counsel on May 11th by email and U.S. mail. Respondent advised that she missed the May 9th, 2022 hearing due to a flat tire and that she advised the court by email of her inability to appear. Later, the May 9th, 2022 email was located in a spam folder by the assigned judge's judicial assistant from the respondent shortly before the hearing was to begin, stating that she was stranded due to a flat tire and her phone battery was dying. Respondent failed to appear at the May 20th hearing, and the magistrate again attempted to reach respondent by phone without success. I mean, as a lawyer, shouldn't you always keep your phone charged? Especially if that's your main source of communication and you know you have shit to do that day. I mean, just a thought. A message from respondent's husband was received by the magistrate shortly after the hearing advising that respondent was in a 3-day trial in Seminole County, Florida. Respondent failed to file any requests for continuances regarding the May 20th, 2022 hearing, nor did she contact opposing counsel to request the hearing be reset. Respondent's client was present at the May 20th hearing and advised the magistrate that he had not had any contact with respondent since the last hearing and asked the magistrate to discharge respondent as his attorney. Sweet baby Jesus. I mean, come on, lady. I mean, what do you say to that? Like, I got nothing good to say about that. Like, just by recommended order of the magistrate dated May 23rd of 2022, the magistrate discharged the respondent as the husband's attorney and referred respondent to the bar. The circuit court adopted the magistrate's recommendation. In her response to the bar, respondent advised that she had only filed a notice of limited appearance to seek a continuance of the hearing on her client's behalf. However, the respondent did not limit her representation to solely seek a continuance. This isn't a spaghetti suit. This is naming all the times that all the misconduct that the Florida bar had received with her representation of her clients. By reason of the foregoing, the respondent has violated the following rules regulating the Florida bar. 3-4.3, misconduct and minor misconduct, again. Diligence, again. And 4-8.4, a lawyer shall not engage in conduct in connection with the practice of law that's prejudicial to the administration of justice. Including to knowingly or through callous indifference, disparage, humiliate, discriminate against litigants, jurors, witnesses, court personnel, or other lawyers on any basis, including but not limited to, on the account of race, ethnicity, gender, and religion, national origin, disability, marital status, sexual orientation, age, socioeconomic status, employment, or physical characteristic. I mean, people. Yeah. Hey, Terry. I was reading her court filings. Nuts. Yeah, this is the Florida bar's suit against her in 2022. Wherefore, the Florida bar prays respondent will be appropriately disciplined in accordance with the provisions and rules regulating the Florida bar as amended. Yep. So that was the Florida bar complaint in 2022. So there's that. I get that. I'm just saying it looks like one. There's just so much. I repeat, how did this not come an issue earlier? How can they get away with this kind of behavior so long? There's the $1 million question. There's the $1 million question. I don't know. I don't. I got no idea. I just, you look at things and you're like, how does this person ever become a lawyer? I look at that with a lot of people. I'm like, how did you ever get to where you how did you ever get to where you Mama, Angel, you want your pad? Yeah. Okay. Yeah. Can you bring it here? Oh, Nana got it. Here, I got it. Book Smart Life, David. Yeah, and guess what? That I mean, I can understand being busy, but maybe you shouldn't take on more clients than you can handle. I mean, oh yeah. Yeah. It's ridiculous.
No, Nana gotta put her laundry in the dryer.
You know, go help Nana?
Yeah.
Go help her.
Come help Nana.
No.
I love you too.
No. And then we have the report of the referee, and once I get through this, then I will call it a day, because the voice can only handle so much at one time. The bar typically will give warnings to attorneys. There's monetary fines or suspension until things get out of hand. Once tired of it, the file for disbarment with the Florida Supreme Court. It's kind of ridiculous. It is kind of ridiculous. I mean, but at the same point, like, how do criminals get arrested so many times and never get punished to what they're supposed to be punished? They just get caught and released, caught and released, caught and released all the time. Oh, Oh, I agree. It just seems like there should be something before you reach 30, 40 complaints. I get it. And I think there should be, like, before you get a bar complaint, like a full-fledged bar complaint, there should be just like almost like a reporting system that's not like a full-fledged bar complaint, but it's like a be on notice of this attorney. And it's something more than just like a Yelp review of their thing, because I know the only people who generally write reviews for law offices and lawyers are people, or any business for that matter, are people who are either very, very satisfied or very pissed. Generally, people don't like, generally the average person who is just satisfied doesn't fill out forms and, write reviews and stuff, because they just go about their business. It's just one of those situations. Yeah. Hey, and we're almost done too. I can only handle so much before my voice starts to. I don't. It doesn't hurt, but it's like it strains to talk. This was filed March 20th of 2023. And remember, she filed her complaint against the Florida bar February 2nd. So there's this going on while she files her complaint against the Florida bar. So there's now two. Yeah. Report of referee, summary of proceedings. Pursuant to the undersigned being duly appointed as referee to conduct disciplinary proceeding herein according to Rule 3-7.6, Rules of Discipline. And that's one thing I have to look up. I have to look up Florida's Rules of Discipline, because I have the Florida bar rules. I have the local rules to Florida's Northern District. I just don't have the disciplinary rules. The following proceedings occurred. On October 13th of 2022, Florida Bar filed its complaint against respondent. Case management conference was held November 9th of 2023. I think they meant 2022 in here. But that's just me. And this is the thing, if you're going to file a summary of proceedings and a report against somebody, especially from this as an actor of the state, you better be accurate. She was facing discipline will read what those discipline that never actually say what the discipline is. And that's the loophole that she was using, I believe, my opinion, that she was using to file that lawsuit against a bunch of people who said that she was facing being disbarred. That's why she retired. Because it never actually says that. So could that have been a possibility? Maybe. But was it ever written down? Not that I can find. And we'll read that. And a final hearing is set for June 6th of 2023. So that's where she would have been receiving her disciplinary, or whatever discipline that she was going to get. On March 8th, 2023, respondents submitted a petition for permanent retirement to the Florida Bar. On March 10th, 2023, the executive director of the Florida Bar accepted the respondent's petition for permanent retirement. Based on the acceptance of the respondent's petition, the bar moved for dismissal of this case as moot on March 16th of 2023. This court entered an order dismissing this case. All items properly filed, including pleadings and the report referee, constitute record in this case and are forwarded to the Supreme Court of Florida. Findings of fact and recommendation. After considering all the pleadings before me, including the bar's motion to dismiss, I recommend that this case be dismissed as a respondent is permanently retired and no longer eligible to practice law in Florida. Pursuant to Rule 1-3.5 of the rules regulating the Florida Bar, respondent is ineligible for reinstatement or readmission to the Florida Bar. In pertinent part, the rules provides as follows. A member who seeks and is approved to permanently retire shall not be eligible for reinstatement or readmission. A retired member shall be entitled to receive such other privileges as the Board of Governors may authorize. See Rule 1-3.5, regulating the rules of the Florida Bar 2019 through 2021. Each party shall bear its own costs. So she was never actually, there was never actually any never actually any discipline. So could she have been facing that? Possibly. But there is no evidence to say that she was. There's the kicker. And that's one of those things that she was using. Yeah, right here. She requested permanent retirement, and there's the loophole too, because she's permanently retired, you can't discipline someone who's retired. So therefore there is no discipline ever because she retired. Because now it's a moot point, because you can't discipline somebody who isn't actively working and who will never be a member of the Florida Bar again. So what was she facing? It's anybody's guess. And I believe that was the loophole. And remember, lawyers like their loopholes. That was the loophole that she was using to be able to say they lied about me or they told a lie because I was not facing this, because technically the documentation never says it. Could it have been something? Could it have been something that she was facing? Potentially. But yeah, she turned in her card when she retired. That's why I say the law firm of disbarred, discarded, and pending. Yeah, just like you can't impeach somebody who's no longer in office. It's just one of those, like, that was the loophole that she hey Lucy, I'm doing okay. That was the that's one of the reasons I wanted to read the document, is to show people, because people were saying, well, she could have, she was going to. It's like, well, technically it's not written down So if it's not written down in a court document, what is it? It's hearsay. Yeah, it's one of those things. I don't disagree with you. It's just one of those things of it wasn't written down in anything from the Florida bar or the Supreme Court of Florida. So therefore, it might not have been. It's the lawyer language, you know, when I'm pretty sure if my parents could unteach me the word technically, they would have, because you know how many times I've used the word technically against my dad and he's gotten angry with me or frustrated with me because well technically, yeah, the bar didn't have to accept her request, but the bar also doesn't like to disbar lawyers. And also, accepting her request saves them money because it takes taxpayer money to do stuff like that. It takes time away from cases that actually, it takes the Supreme Court of Florida away from cases that actually need to be heard for something stupid. And I'm going to say something stupid as a lawyer who needs to be disciplined. So it's one of those catch-22s of language that, do I agree with it? No. But do I understand the logic that she was using? Or I believe what I believe is the logic that she was using from a lawyer's perspective, even though I'm not a lawyer. But I have that, like, ask my parents. I have that brain where it's like, technically, technically, I'm annoying like that. I'm annoying like that. I like it. Oh, yes, I agree. It's not a stretch. I agree. However, Jeff, you know that lawyers like their words. And if it's not in a document where it says this is what you're potentially facing, it's not in the thing. It's not in the document. It's hearsay. And if you present it as fact when it's not actually a fact, technically speaking, it's that catch-22. And that's why words are important. Like it's that words are important. Yeah. Yeah, pretty much. I would get that, like, this is what I do. This is why my parents find me so damn annoying sometimes. But I believe if I actually went to law school, that what is one of the things where if I went to law school, I'm not trying to toot my own horn or anything because I'm not a lawyer and I don't have the patience. However, if I actually went to law school, that is one of the things that I believe might have made me a good lawyer, because those catch-22s and those loopholes are things that I am good at finding. And I like to argue. I like to prove people wrong. And yeah. See, that's the thing. Here's the other catch-22. Technically speaking, she's not practicing law because she's representing herself pro se. And any idiot off the street can be pro se. Anybody off the street, I could go, like, walk down the road and just say, hey, you, file a lawsuit. And so technically speaking, she is pro se. Anybody can be pro se. Just because she is pro se but has a law degree does not make her practicing law. It makes her a pro se defendant. She just happens to have the education of a lawyer. It's one of those catch-22s. She can't represent anybody else, but she can represent herself. There's the other. Yeah, there's the. Oh, and I don't disagree with you. And that's the thing. I'm not trying to disagree and saying that wasn't a Hold on 1 second. I got to return a message.
Who's that? Who's the baby?
So it's
That's
it's
you.
I don't disagree with you. However, it's that technicality of
You.
if it's not in the documents that's what she was going to get punished with. By saying that's what she was going to get punished with is technically stating a mistruth. Even though you can imply it, it's not, you know. Mm-mm. So it's one of those like, yeah. And technically speaking, any idiot can give legal advice. See, and that's that right there could be an issue. That right there could be an issue. But it's one of those what do you know versus what can you prove? There's what I was trying to say about the whole her potentially losing her or being disbarred. It's what do you think might happen, what do you know versus what can you prove? Generally, there are two different things. So, it's a. Oh yeah, and I don't disagree. I don't disagree with any of you guys. By saying that was a very good possibility and that might have happened, but because when someone is that litigious, they will find loopholes, and that is a loophole. Not saying I agree with the logic. I'm just saying that might be the logic. So, it's just one of those. That one makes me question things because
Who's that?
this is the
That's you. That's me.
this is the complaint she filed against the ABC Legal, the people who filed the or tried to serve her. So this is ABC Legal. AMF is a minor child, so you can see when she files plaintiff Leslie, retired attorney representing herself pro se, and AMF represented by undersigned counsel. This could be where it gets hinky. Because if look at who signed it. He signed it, but he's representing the child, she's representing herself. But that could be hinky because technically is he truly the one representing himself, or is she just saying that he's representing the child and she's actually doing it and he's just a placeholder when he needs to show up? But she's actually doing the writing and things like that. It's one of those. Yeah, but it's one of those things of what do you know versus what can you prove? There's the other thing. Like, it's always what do you know versus what can you prove? And that's a lot of times why people don't get in trouble for things, because you know someone's doing some shady shit, but can you prove it? It's and a screenshot, as much as I would like to say that would work, it's with as much things that can be doctored these days, you would have to prove that those screenshots aren't doctored. And it's possible. It's just one of those, like, it's just one of those. It's one of those difficult situations between what can you prove. Yeah, it's enough to get your into court, but not enough to win. It's always like, you know, back in the 80s, I was a PI, and we can work from a licensed PI license until you got your own. There had to be a license in that office. See, and like when you're a student, when you're like a OTA or an OT or a PT or a PTA, and you're a student, technically speaking, when you're a student and you are in your level 2 clinicals, you can work under their license. So they're responsible for you. So like if I was a student, I could go treat a patient, but and even as an OTA, I could treat a patient, but I'd always have to have a OT sign my notes, because yes, I have an OTA license, but I don't have an OT license. It's all a bunch of legal mumbo jumbo, and every profession is different. It's like, what can a legal assistant do versus a paralegal? And what can a paralegal who has a certificate do versus a paralegal who has an associate's degree? I'm sure there are different levels of what they can do based on their education. And also there is like OT. I'm a CLT. I can treat lymphedema, and I can sign off on lymphedema patients. Other therapists can treat lymphedema, but technically speaking, they can't do the lymphedema treatments because they are not a CLT, whereas I am. So it's all about what. Yeah, this is. It's all. Yeah, if it was civil, preponderance of the evidence says she is, but since it would be criminal, can't be proven. That's one thing about our justice system, is it's so complex, and it's designed to prevent people who are not guilty from being falsely committed or convicted. So it's like, what's that phrase? I would rather have that one person go free than one guilty person go free, or 10 guilty people go free than one innocent person be convicted. So it depends on the what you're treating, what insurance they have. On acute care, it was a little different than like rehab, because acute care therapy is just included in your stay, and I don't have to ask insurance to get money for treatments. It's just part of here at our hospital. It's included. If the doctor puts in it's part of your charges that you get charged in the hospital. It's not a reimbursement through insurance, but on the rehab floor, it's different in an inpatient rehab versus a subacute rehab, like a nursing home. Nursing home, if the person has a straight Medicare, if they have a supplement, if they have Medicaid, it's different. If they have, I can't remember all the different types of insurance right now. But it's basically what insurance company. They have different requirements for how many times notes have to be signed, and also that each state has different requirements. In Georgia, I can't do certain things with patients without being licensed in each or certified in each of those. Like I can do e-stim in Wisconsin. I can do e-stim on a patient without a problem. In Georgia, I need to be certified that I know how to use that e-stim properly. And just remember, everything is nuanced. There's not a one size fits all for everything, and that's what makes life so complicated, because every situation is different, and it's not about what we know. There's also the difference between what is ethically wrong and what is legally wrong. I had this conversation with somebody yesterday. I was talking to them on the phone, and I was talking to them, and they were worried about something. And I was like, there is a difference between what is ethically, like, would I go around calling a random stranger an asshole? No, I wouldn't, because they didn't do anything to me. Is that ethically right for me to do that to someone? No. But is it illegal for me to run around calling a random stranger an asshole? No, it's not illegal. It's not illegal to be it's not illegal, and you're not defaming anybody by being a douchebag. So there's like ethically wrong, morally wrong, and legally wrong. There's two different standards. And I believe that a lot of people, especially when they're talking about defamation, they apply their ethical and moral standards and not the legal standards, because they're different. There's this too. If someone puts in prison for murder and they're really innocent, that means there's a murderer free while the innocent is in prison. They fight to retry evidence that could exonerate them. It's all right. On that note, though, I do have to get going. I do want to try to make it to the gym today. And I appreciate everybody. And there's always one person on my streams that on any stream that has anything to do with anything What the Hills, there's always one person who goes through, because we have 58 likes and 1 dislike. There's always one person. My stream from a couple days ago, 135 likes, 1 dislike. Reading through Bruce's lawyer's response, 168 likes, 1 dislike. Like there's always one. Yeah, and this is the thing too. I think the issue is no legal closure of her case due to technical issue of permanent retirement with no to reinstate. Rates different opinions. And that's the same thing with, like, say a family who's who their child was taken away from them there was unalived by somebody, and instead of that person facing justice, that person unalived themselves, or self-deleted. It's like there's no closure. The family gets no closure. So the people who she wronged, according to this complaint, the people who she wronged get no closure. And that's a huge thing too. And it can be debated till the end of time, because we will never know, because it's not written down what would have been her punishments. And if it's written down, it's not put into the record. So it's that it's like that you can debate it till the end of time. Who knows what it actually, what actually will happen. And it's just one of those. But that's the loophole that she was using. In my opinion, it was a loophole that she was using. That was the logic that I believe that she was using to file that lawsuit. Do I agree with it? No. However, can I see the logic as someone with a 1,000-foot view? I can see the logic. I don't agree with the logic, but I can see the logic if you're that kind of person. So, oh, you're funny. All right, I do have you guys set up to redirect to Mo. She is doing Karen Reed day 30 of that shit show. And if you haven't followed the Karen Reed shit show, there's a reason why I can't stream it. 1, it's too long, and 2, it makes me want to beat my head up against a wall, because the state is just the state. And it's one of those things of, remember, however much you might like judges or like prosecutors, the prosecutor and the judge are on the same team. They're both actors of the state. So anyway, I will see you guys tomorrow. Probably be doing a stream tomorrow morning, but I will be doing a stream tomorrow afternoon talking with Spawn about the ATC stuff. We are going to do every Wednesday at 3 o'clock Eastern time. We are going to do ATC deep dives into government corruption, following the money and all that. You want to say goodbye?
Bye.
Want to say goodbye?
Bye. See ya. Nana hasn't killed her.
Yeah. Say I'll see you guys later.
Bye.
All right. Y'all have a great day. Say hi to Mo. Tell her I love her. Bye, guys.
Okay.